Honorable members, I come before you today to address a matter of significant public interest and concern: the laying and subsequent withdrawal of the Road Traffic Amendment Regulations. Honorable Member, this proposed legislative instrument laid before this esteemed House on the 14th of June, 2024, and was set to mature on the 19th of July, 2024, sparked considerable discourse and discontent among the Ghanaian populace. The proposed amendment sought to grant certain public officials, including ministers of state, members of parliament, and justices of the superior courts of judicature, the privilege of using sirens on our roads and exemption from speed limits. Honorable members from Western Region, this provision has been perceived by many as a means for the political class to evade the very traffic challenges that affect the general public, leading to widespread public outcry and intense debate on social media platforms. In light of these developments, and following the opposition's firm stance against the legislative instrument, the government has decided to withdraw the proposed amendments. Today, I wish to address the very key issues arising from this situation, provide clarity on the legislative process, and engage in a constructive dialogue about the future of subsidiary legislation in our beloved country. We recognize the public's perception of insensitivity, and I'm here to offer an apology and assure the Ghanaian people that this Parliament remains acutely aware of and responsive to their needs. Furthermore, I will outline the process of subsidiary legislation making, clarify the steps we have taken to streamline this process through our new standing orders, and invite a robust debate on whether the current constitutional framework for subsidiary legislation is fit for purpose. As a House, it is a duty to approach every matter of public concern and interest with the seriousness it deserves, acknowledging the concerns of our constituents and working collaboratively to enhance the legislative process for the betterment of all Ghanaians. Honorable members, to fully appreciate the events surrounding the Road Traffic Amendment Regulations, it is important as a matter of public education to outline the process of making subsidiary legislation in Ghana. Subsidiary legislation, also known as delegated or secondary legislation, is legislation made by an individual or body and the powers given to them by an act of parliament or by the Constitution. The scope and purpose of subsidiary legislation have their roots in common law, designed to provide detailed provisions or administrative measures necessary to enforce primary legislation. Subsidiary legislation allows for more flexibility, responsive, and detailed regulations that can be swiftly amended or introduced without the need to pass a new act of parliament. This type of legislation ensures that technical and procedural matters can be dealt with efficiently by those with the relevant expertise. Article 11, Clause 1C of the Constitution of the Republic of Ghana provides that the laws of Ghana shall comprise, and I quote, any orders, rules, and regulations made by any person or authority under a power conferred by this Constitution, unquote. Therefore, subsidiary legislation forms an integral part of the legal framework of Ghana. In Ghana, there are two primary types of subsidiary legislation. One, constitutional instruments, referred to as CIs, and two, legislative instruments, referred to as LIs. CIs are made pursuant to powers conferred by the Constitution itself. They are typically used to deal with matters of constitutional importance, providing the necessary details for the implementation of constitutional provisions. LIs are made under powers conferred by an act of parliament. LIs are generally used to make detailed rules and regulations necessary for the enforcement of primary legislation. The road traffic regulations, for instance, exist to ensure the proper enforcement of its primary legislation, the Road Traffic Act. The process of making CRs and LIs is governed by Article 11.7 of the Constitution, which outlines a clear and structured procedure. Any order, rule, or regulation made under a power conferred by the Constitution or any other law must be laid before Parliament. The instrument must be published in the Gazette on the same day it is laid before Parliament. The instrument comes into force at the expiration of 21 sitting days after being laid before Parliament, unless annulled by Parliament. If Parliament, by a vote of not less than 2/3 of all its members, annuls the order, rule, or regulation within the 21 days, the instrument does not come into force. In the case of Okine and others versus Electoral Commission and Attorney General, and affirmed in Ni Tete Opreme versus Attorney General and others, and again Nana Kwatim Penyin Akosa II and others versus the Attorney General, the Supreme Court outlined the authority of Parliament concerning subsidiary legislation. The court, in my humble view, held rightly that Parliament does not have the authority to amend any order, rule, or regulation laid before it under Article 11.7. Parliament has only two options: to allow the instrument to pass after 21 sitting days, or to annul the entire instrument by a 2/3 majority vote. This judicial interpretation underscores the non-amendable nature of subsidiary legislation once laid before Parliament. Honorable members, building on the judicial interpretations and the constitutional process, Parliament has developed a more rigorous framework within its new standing orders to enhance the scrutiny and efficacy of subsidiary legislation. This framework leverages the powers conferred by Article 110 of the Constitution, which allows Parliament to regulate its own procedures. To ensure that subsidiary legislation serves the public interest and adheres to constitutional and legal standards, Parliament has empowered the Subsidiary Legislation Committee with a critical mandate. The committee's responsibilities are set out under Order 220 to include: 1, ensuring that proposed subsidiary legislation aligns with the constitutional with the Constitution, Acts of Parliament, and other laws. 2, detecting any potential inconsistencies, ambiguities, or concerns in the proposed legislation. And 3, offering inputs and recommendations to refine and improve the proposed legislation. Recognizing the importance of thorough scrutiny, Parliament has instituted a pre-laying process. This process mandates that the relevant person intending to lay the LI or CI engages with the Subsidiary Legislation Committee for a comprehensive review before the instrument is officially laid before Parliament. This pre-laying engagement is essential for several reasons. 1, by reviewing the proposed subsidiary legislation beforehand, the committee can address potential inconsistencies with the Constitution and other laws and secure the interest of the Ghanaian people. 2, since a proposed LI or CI may come into force without further input once laid before Parliament, the pre-laying process helps avoid the odious task of securing a 2/3 majority to annul problematic instruments or waiting for judicial intervention. And 3, the committee's inputs and recommendations during the pre-laying stage ensure that the subsidiary legislation is robust, comprehensive, and reflective of public interest. Honorable members, it is important to acknowledge that the proposed amendments to the Road Traffic Amendment Regulations, which have since been withdrawn, were indeed recommended by the committee to the ministry during the pre-laying stage. Since the LR had then not been brought to the Speaker to admit, nor presented as part of the business of the House, neither the Speaker nor non-members of the committee knew such amendments had been made by the committee at the pre-laying discussions. This process, though regrettable in this instance, does not detract from the overall importance and efficacy of the pre-laying procedure. In admitting the shortcomings of the particular instance, we reaffirm our commitment to refining and improving our legislative processes. We recognize the concerns of the Ghanaian people and assure them that such issues will be diligently addressed moving forward. Honorable members, as we reflect on the events surrounding the Road Traffic Amendment Regulations, it becomes imperative to consider the broader implications of our current process for making subsidiary legislation. This moment presents an opportunity for us to critically assess whether our existing framework is truly fit for purpose and to explore potential reforms that could enhance legislative scrutiny and accountability. Unlike substantive acts of Parliament, which undergo multiple readings, debates, and detailed scrutiny, subsidiary legislation often receives less rigorous examination. This limited oversight can result in provisions that may not fully align with the broader legislative intent or public interest. Acts also typically involve extensive public consultation and stakeholder engagement. In contrast, the process for subsidiary legislation does not include sufficient opportunities for public input, leading to a lack of transparency and potential disconnect with the needs and concerns of the citizenry. Subsidiary legislation by this nature allows for the delegation of legislative powers to individuals or bodies other than Parliament. While this can be efficient, it also carries the risk of overreach, where the delegated authority might enact legislations that extend beyond the intended scope or infringe on fundamental rights and freedoms. One of such legislation is regulations on the Lands Act will have to be looked at critically. It touches this area. Further, as highlighted, the process for annulling problematic subsidiary legislation requires a 2/3 majority in Parliament. This high threshold can make it challenging to address issues swiftly, potentially allowing flawed regulations to remain in force and impact the public adversely. Finally, relying on judicial interpretation to impede subsidiary legislation is neither timely nor efficient. Court proceedings can be lengthy and costly, and they should be a last resort rather than a primary means of ensuring legislative compliance and quality. Honorable members, given these considerations, it is perhaps time as a country to deliberate on whether our current approach to subsidiary legislation adequately serves the needs of our democracy. We must ask ourselves, 1, could introducing multiple stages of review akin to the process for substantive acts enhance the quality and accountability of subsidiary legislation? 2, can we ensure that subsidiary legislation is subject to more extensive public consultation and stakeholder input, thereby enhancing transparency and responsiveness? 3, should we consider the 2/3 majority requirement for annulling subsidiary legislation, making it more feasible to address problematic regulations promptly? And 4th, how can we better delineate the scope of authority granted for making subsidiary legislation to prevent overreach and safeguard fundamental rights? Don't forget that the final authority and responsibility for lawmaking resides in Parliament. Honorable members, these questions are crucial as we strive to uphold the principles of good governance, transparency, and accountability. I hope we as a country can engage in a robust debate on the appropriateness of our current legislative mode for subsidiary legislation and exploit potential reforms that will better serve the interests of the Ghanaian people. Honorable members, in conclusion, as we reflect on the issues arising from the laying and subsequent withdrawal of the road traffic amendment regulations, it is evident that our legislative processes, particularly for subsidiary legislation, require continuous evaluation and improvement. While the pre-laying process and the work of the Subsidiary Legislation Committee are crucial steps in ensuring the quality and constitutional alignment of our laws, the events surrounding this proposed LI highlight areas where we can enhance transparency, accountability, and public engagement. Our commitment to the Ghanaian people mandates that we remain vigilant and proactive in refining our legislative processes and procedures. The concerns raised by our constituents remind us that the laws we create must not only be just and effective, but also perceived as such by those we serve. By addressing the perceived insensitivity and reaffirming our dedication to public welfare, we uphold the trust placed in us as representatives of the people. The debate we generate today about the process of subsidiary legislation is not just about rectifying a past misstep, but about forging a path forward that strengthens our democracy. Let us embrace this opportunity to engage in meaningful dialogue, consider potential reforms, and ensure that our legislative processes are robust and reflective of the highest democratic principles. To set the process in motion, I have, on behalf of Parliament, given notice to the Chief Justice of the intention of Parliament to engage the judiciary in a conversation to set the processes and rules of procedure of Parliament subject to Article 110 of the Constitution, 1992. Finally, honorable members, let us move forward with a renewed commitment to excellence in our legislative duties, ensuring that the laws of Ghana reflect the highest standards of governance and serve the best interests of our people.